This is the second video in this series on formalities and constitution, which is aimed at law students who are studying equity and trusts as part of an undergraduate law degree. The videos are bite-sized, so you will need to expand your knowledge by looking at the course materials or the recommended reading list for your course. Here's a note of the next two videos in the series that I will be working on, and I recommend that you watch the videos in order. If you are waiting for the next one, I'm sorry it takes me a long time between videos. This is a bit of a hobby of mine and it does take me a long time to make them as I'm on a very steep learning curve. So this is a slide taken from the first video in this series when we looked at what is meant by formalities, and we saw that there are often two stages to setting up a trust. And in the first video we concentrated on the formalities to declare the trust itself, and in particular a trust over land. Constitution is the second stage. So it's not enough just to declare your trust if you're appointing trustees. You also have to transfer the trust property to them. And note that these two stages don't have to be contemporaneous. For example, a property owner could declare he's setting up a trust one day and then actually transfer the property to his trustees at a later date. I now want to look at what we mean by constitution in the context of equity and trusts. Here's a very basic definition. So constitution is when making a voluntary disposition of property, the legal requirements to transfer the property must be complied with. And I'm going to break that definition down into bite-sized pieces, and first we're going to look at what we mean by a voluntary disposition of property. So constitution is important in relation to voluntary dispositions of property. In other words, when a property owner makes a gift of their property. So how can you make a gift? Well, there are three basic ways. First of all, you could make an outright gift. So for example, your parents might give you £5,000 towards the cost of your wedding. That would be an outright gift, and lawyers would describe that as a transfer of beneficial ownership, so that you, the transferee or the donee, owns the property absolutely after the transfer. The second way is that you could transfer the property into a trust, and in most trusts where trustees are appointed, beneficiaries have not provided any consideration for the transaction, so it's a voluntary disposition. And the third way is that the property owner could make himself a trustee of the property for someone else. In practice, that is the least common option. So a gift is where the recipient or beneficiary hasn't provided any consideration, and we call them volunteers. So here are three different examples of gifts that a property owner might want to make. And the first one is that the property owner intends to give away his holiday cottage to his children. So he's going to make an outright gift, and the children haven't provided any consideration, so they're volunteers. The second way of making a gift is that you can set up a trust over your property by appointing trustees and transferring the trust property to them to hold on trust for the beneficiaries. So here the property owner is declaring that she's going to transfer her holiday cottage to Tamsin Antica to hold on trust for her children. And again, the children haven't provided any consideration, so they're volunteers. And finally, the property owner could make himself a trustee of the property. So he declares that he's holding his holiday cottage on trust for his children, and again the children are volunteers. Now let's go back to the definition and look at the second part, the need to transfer the property. So constitution is about the transfer of ownership or transfer of title, as lawyers would say. So you constitute a trust by vesting, that's another lawyer's word, title in either the trustee or trustees if there's more than one, or by vesting title in the donee if it's an absolute gift. So the property owner may need to transfer title to the property, and we looked at this in the first video. And we saw that the type of property then tells us which formalities are required in order to achieve that. So here are a couple of examples just to illustrate that point. So the first example is where a property owner needs to transfer legal title to an estate in land. Well, in that situation, the correct formalities to transfer that type of property are that the property owner needs to execute a deed, and then the change of ownership needs to be registered at the land registry. And it's only until that final stage is completed that legal title actually passes to the transferee. And the second example, just to contrast the differing requirements, here what the property owner needs to do is to transfer legal title to shares. So the type of property is different, but what the property owner needs to do is the same. We're looking at transferring legal title. So here what the property owner has to do is to complete a particular form, which is known as a stock transfer form or a share transfer form. And that form needs to go to the company, and the company will then update its records so that the new owner of shares is reflected on their shareholders register. And again, it's only until that final stage has been completed that legal title to the shares transfers to the new owner. So in assessment and seminar problems on constitution, they are usually all about when things don't go as the property owner had intended, so things don't go to plan. For example, if a property owner intended to make a gift of land, perhaps the transfer hadn't been sent to the land registry, and then the property owner drops dead. Or perhaps it's a trust of shares and the property owner dies before the company has updated its share register to show the trustees as the new owner of the shares, so the final stage wasn't completed. And we call this situation an imperfect gift. And you'll see how this fits in the next video when we look at the equitable principle that equity won't assist a volunteer. So a volunteer can't enforce a promise to transfer property in equity, and we will look at that in more detail when we look at the case of Milroy and Lord. So constitution is essentially about transferring title to property to the intended recipients. If you've already studied constitution and you're watching this video to revise for an assessment or simply to check and consolidate your understanding, then the next couple of points are for you, and I'm going to take you through a couple of mistakes that I have seen students make. And the first one is to check the facts of the question carefully to make sure that you reach the correct conclusion regarding the intention of the property owner. I have seen students conclude that the property owner intended to create a trust, when in fact it was really obvious that the intention was to make an outright gift. So just because the exam paper is headed up Equity and Trusts, don't assume that a trust is intended. You're looking at equitable principles which apply to outright gifts as well as trusts. And if the examiner thinks that you can't tell the difference between a trust and an outright gift, when it's very, very clear on the facts, then that's not going to make a very good impression. And I think why students make this mistake is because of the second point on the slide there, that the requirements to constitute an outright gift and a trust by transfer to trustees are the same when you're dealing with the same type of property. So here's an example of that. You can see that the intended dispositions here are different. Samira intends to make an outright gift, but Sadiq wants to set up a trust appointing trustees. Now they both intend to make a voluntary disposition, but the method that they want to use, or the mode as it's called, as we shall see later, in each case is different. But they both have to transfer legal title to land to achieve what they intend to do, and the requirements to do this are the same. So in both instances they need to execute a deed, and the requirements for registration under the Land Registration Act 2002 need to be complied with. So just to go back to our earlier examples, the subject matter is the same, and so the transfer requirements are the same, but the intended method or the intended mode is different. Now this may seem a very obvious point, but you would be surprised at how many students are determined to find an intention to create a trust when the facts very clearly indicate that it's an outright gift. The second error is more common than you would expect, and it's more serious. So you'll find that I talk about this problem at several points in my videos, and it's also in the consolidation video, 10 key points, which you might want to check out when you're consolidating and revising this topic. And the problem is this. Here, the property owner is going to be the trustee. So no transfer is required. He already holds the title to the trust property, so the trust is already constituted. What is happening here is that the children have obtained a new equitable beneficial interest in the property, and the property owner, who is now the trustee, continues to hold the legal title. And of course remember that because it's land, the declaration of trust must be evidenced in signed writing under section 53(1)(b). Here's another illustration. Imagine this scenario. The property owner is giving away his beneficial interests in the shares in BSL by declaring a trust over them. So he will hold them on trust for his children. And hopefully you will know that he can do this very easily. He can simply declare the trust. He doesn't even have to put it in writing because it's personality, although obviously in practice it's a good idea to do so. And this is the error that students make. They start looking at the formalities or requirements to transfer legal title to the shares. But here's the problem. He doesn't have to do anything to constitute this trust. He already has the legal title. So if the property owner, the settlor, is going to be the trustee, he doesn't have to transfer title to the trust property to himself. And hopefully you can now appreciate why this is a silly and serious mistake to make in an assessment. It would be a totally relevant discussion, and what's worse is that you'll demonstrate to the examiner that you don't understand what's going on when you set up a trust in this way. Now that reminds me, I have 25 years experience teaching law students, and I now offer private tuition, so if that's something that you're interested in, please feel free to get in touch. You'll find more details about me on my channel page. Just be aware that I don't provide an assessment writing service. I have been asked quite a few times to write answers to assessments, and I have always refused, but I will provide feedback and guidance on students' own draft assessments and sort out any areas that they've got wrong or don't understand. So now we've seen what's meant by constitution, and here's just a mental checklist for you which you'll be going through when you're looking at a question involving constitution. So first of all, is it a voluntary disposition? Secondly, does the property owner need to transfer title to the property? If the answer to that is yes, you then need to see whether the property was actually transferred by looking at the facts and working out what has happened. If you conclude that the property wasn't transferred, then you're going to be looking at the equitable principles that I'll be covering in the next video. So thank you for watching. There are my contact details on the slide there. I do also post on the Student Room website. There is a law study help forum, and I do occasionally post on that. My username is BiteSize Law, and more recently I'm posting as Law School Hack, and I use the melon slice logo so you'll be able to tell that it's me. Coming up in the next video, we're going to look at why this all matters. So we're going to be looking at the equitable maxim that equity will not perfect an imperfect gift. Thank you again for watching. I do hope that you found this video useful. Please consider subscribing to my channel and also add any comments on the video in the box below, as it really does help.